Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if an employer makes an erroneous payment to an employee. The question is whether this payment may be deducted. The matter I want to discuss is the case of Northwest Provincial Legislature versus Nahawu, wherein the Labour Appeal Court considered whether erroneously paid salaries to striking employees can or may be recouped. Now, in discussing deductions, colleagues, especially deductions from an employee's remuneration, we have to look at the provisions of Section 34 of the Basic Conditions of Employment Act. This section prohibits an employer from making a deduction from an employee's remuneration unless the deduction is by agreement, the deduction is required or permitted in terms of a law, a collective agreement, a court order, or an arbitration award. But what happened in the Nahawu matter? So from 16 November 2020 until at least 15 December 2020, employees engaged in unprotected strike action. On 16 November 2020, the Secretary of the employer issued a communication to staff members informing them that given the unprotected industrial action, the principle of no work, no pay would apply to those employees who did not work. On the 27th of November 2020, the Labour Court interdicted the strike and declared it unlawful. On 14 December 2020, the Secretary issued a further communique to staff that the principle of no work, no pay was to be implemented from the 15th of December. But despite the communiques issued, the remuneration was paid to all striking employees, apparently because the employer failed to halt its payroll run to striking workers. Following this, the employer advised the employees that it would deduct the remuneration paid to employees who had been on strike from their salaries over a number of months. It was said that 3 working days remuneration will be deducted each month from employees' remuneration, and the employees were not happy with this. So, Nahawu approached the Labour Court to interdict the employer from making the deductions and to determine whether the deductions that were made were in contravention of the BCA and unlawful. The Labour Court found that Section 34, subsection 1 applies to any deduction from an employee's remuneration. It further found that the deductions that the employer sought to make from the employee's salaries were unlawful, and it interdicted the employer from making any deduction until it had complied with Section 34 of the Basic Conditions of Employment Act. The employer was not happy with this interdict and appealed the decision. So on appeal to the Labour Appeal Court, the employer argued that the strict requirements of Section 34 do not find application in circumstances where the principle of no work, no pay may be resorted to. The employer further contended that the principle of no work, no pay constitutes a deduction effected in terms of a law as permitted by Section 34, and that the recovery of this unearned salary would not amount to self-help on the basis of set-off. Now, the LAC or the Labour Appeal Court accepted that the principle of no work, no pay entitles an employer to withhold payment of remuneration to its employees where no services are rendered during an unprotected strike. It pointed out, however, that in this case, the employer had failed to exercise this entitlement. The court found that payments made during a strike or this strike constituted remuneration as defined in the Labour Relations Act. This meant that the restrictions as contained in Section 34 applied. In this case, there had been no agreement to deduct amounts from the strikers' salaries, and deductions had not been required or permitted by a law, a collective agreement, an arbitration award, or a court order. The court said that the principle of no work, no pay did not constitute a law as envisaged in Section 34. The court also rejected the argument that the employer was entitled to apply set-off to the monies paid to the strikers against future remuneration payments. The court pointed out that for set-off to take place, the debts that are being set off against each other must be liquidated and fully due. The court said that the extent of any indebtedness, if any, of the employees to the employer in this case, was still in dispute, and it could not be said that there was a debt that was due and payable. So the Labour Appeal Court accordingly agreed with the Labour Court and found that the deductions were unlawful, and the appeal was therefore dismissed. But colleagues, it is worth noting that determining the existence of a debt differs from figuring out how to recover an acknowledged debt. In this instance, the court acknowledged the potential indebtedness of employees to the employer, but ruled out recouping it through Section 34 deductions. Litigation might be the avenue for this specific recovery. Additionally, South African courts emphasize once again the necessity of the rule against self-help to safeguard employees from arbitrary employer decisions. The court in this matter confirmed that the principle of set-off cannot be applied in circumstances where there is an unresolved dispute as to the extent of any liability, if any, that an employee may have towards an employer. The judgment also underscores the importance for employers to ensure deductions align with agreements, laws, collective agreements, court orders, or, as we have mentioned, arbitration awards. This case highlights the need for timely application of the no work, no pay principle during strikes to avoid complications in recouping payments. Colleagues, that brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative. If you have any questions or comments, we'd love to hear from you. As I've mentioned before, you can find us on social media, or you can email us at info@masconsulting.co.za. I will see you in 2 weeks' time. Bye-bye.